Mr. McKinney, this attorney has recently been appointed to represent you, so they need to make sure they have discovery and everything. You understand?
Yes, I understand fully, Ms.
All
Boyd.
right, do you have any questions about anything?
If you would allow me, I'd like to bring to the court's attention my recent remagistration.
All right, that's something, because that's legal, that's something you'll need to speak to your attorney about.
No, I understood. It's just why I have the opportunity to establish a record, considering that he just got appointed at that time. Mr. Jimenez was my attorney. The magistration was held with me not having any counsel.
So let me explain something to you, and if I'm wrong on the law, I'm sure your attorney will correct me. But when you're magistrated, it's not an adversarial process. The only thing the magistrate judge is doing is telling you what your rights are and setting a bond.
From what I'm aware of, it's Supreme Court ruling stating that you are allowed the assistance of counsel through all criminal proceedings.
Okay.
And in that particular matter, I was negated that right under the Sixth Amendment of the United States Constitution.
All
So
right,
I
if
just
you,
like to get the court's record established with that.
no problem. We can put that on the record if you want to put that on the record.
Yes, ma'am, I would love to, please.
Sure. All right, court is calling 2024 CR 009238, 2024 PF 16224, and 2024 PF 16225. State of Texas versus Raymond Lee McKinney. Can I have parties announced for the record for the state?
And fair settlement.
Defense,
Robert Mauer for defendant.
are you Mr. McKinney?
Yes, I am, Ms. Boyd.
All right, can you raise your right hand for me, please?
That'd be difficult. And
Well, no, because I need to swear you in.
okay,
You solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
no disrespect to the court, Ms. Boyd.
Well, here's the thing.
I don't swear. That's why I'm trying to bring to
Alright.
your attention. I don't
All
swear.
right, let me ask you this. Do you affirm that you will tell the truth and nothing but the truth?
I guarantee to the court that I would definitely tell the truth, and I'm
Alright.
aware of perjury.
All right,
And
you wanted to
that I
place
won't
something,
do.
you wanted to place something on the record?
Yes, ma'am.
You may proceed.
I'd like to place on the record that I was recently magistrated by Judge Ramirez. It was this past Thursday or Friday, if I'm not mistaken. And I was without counsel. And from my understanding, the Sixth Amendment grants you the right in all criminal proceedings to be able to have this assistance of counsel, which I didn't have during that remagistration. During my first magistration, counsel was provided through the public defender's office, and that was negated in this recent remagistration. So I want to just make sure that it was brought to the court's attention and the record was established with that. So there could be an objection that the court was notified of in that regard.
All right, you said something interesting. You said that the public defender's office was present?
In the first, and that was
Okay.
June 14th
Okay.
of this year.
All right. Defense, is there anything you wish to add?
No, Judge.
All right, thank you for letting me know.
Yes, ma'am. Thank
And
you.
there's a record and it's been preserved, okay?
Yes, ma'am.
All right, thank you.
Yes, ma'am.
Thank you, Judge. I'll see you on the 7th.
All right, thank you. So let me explain something to you. I don't know what your issue with your attorney is, but I'm going to tell you what I've told every person who's been before me, right?
Yes, ma'am.
I've been a defense attorney. I've been a prosecutor.
Yes, ma'am.
Now, I run my court a certain way because when I was a defense attorney and a prosecutor, you pick up things from other judges and then you decide what you feel would work and what you would have liked if you were a defense attorney or prosecutor.
Yes, ma'am.
So in this court, I require that I make sure that everybody have all their discovery. Of course, we're not going to be up in here a year waiting for discovery, right?
Yes, ma'am.
Then the other thing I require that attorneys receive offers from the state.
Right.
And when your attorney receives an offer, ethically, they're obligated to give that to you. Now, you may think that offer is ridiculous, right? But I tell people, let's not say those words because then people get here. And I want everybody to be at this level when they negotiate. So if your attorney gives you an offer, that's the offer the state has made. Defense attorneys, this is what people think. Defense attorneys believe sometimes, defendants believe sometimes that defense attorneys can control what offer the state is going to make. They really can't. All they can do is they could present maybe mitigation to the state and say, hey, this is why you should consider giving this person probation. Or either they can present something to them and say, this is why this case should be dismissed.
Yes, ma'am.
And then you know what the state will do? In this court, I will tell you, the state will consider the argument that the defense is making.
Yes, ma'am.
And you know what they could say? You know what? You're right. We're going to dismiss it. Or you know what? You're right. The offer that we're making is too much.
Yes,
That's
ma'am.
what they may say.
Yes, ma'am.
Or they may say, no, this is the only offer we're making. And then once your attorney presents that offer to you, you have one or two choices. You can say, I'll accept it, or you can say, I won't accept that, but let me make a counter offer. Tell the state I'm willing to accept A, B, and C. And then your attorney will let the state know he won't accept that, but here's a counter offer for you. And then guess what? The state can say, oh, let's consider that. And they can say, yeah, we'll accept this counter offer. They can say, no, the only thing we're offering is A. And then your attorney will bring that back to you. And then now you have a choice. Either you're accepting what the state's offer, or either you want a jury trial. That's the thing. Now, I can tell you, some attorneys have great bedside manners. What do I mean by that? They sit with you, they hold your hand, they talk to you about how your day is going, how's your family doing. There are some attorneys, they're not into that. They're like, I'm here about this specific case. These are the elements the state needs to prove. These are the facts I have. And this is police report. Let me defend you. So that's where we are.
Yes, ma'am.
So what is your issue?
My issue is Mr. McCray would not let me get one word in. Judge Boyd, I wanted to at least speak my testimony.
All right, so let me talk to you about speaking your testimony. If you're speaking of your testimony is something that you want to present to me,
Yes.
the only time you're allowed to present that to me is if you decide to testify. And I'm sure your attorney has told you, that's completely up to you, whether you testify or not.
Yes, ma'am.
And I'm sure Mr. McCray has probably told you the good things and the bad things if you decided you wanted to testify. Right? As far as speaking to me and saying, oh, my case should be dismissed, and here are the facts that I want to tell you, this is not the part of the process where I received that information. The part of the process where I received that information is if you have some kind of mitigation. For example, if you say, yeah, I could hypothetically, yeah, I committed a theft, but let me tell you why I committed that theft. I'm starving or something of that nature. I'm trying to feed my children. Doesn't mean that you didn't do it. It just means that you're trying to say, Judge, go a little light on me, because let me just tell you about my life.
Okay.
All right.
Yes, ma'am.
So
Yes, ma'am.
that's the only time. So for you to be telling me what you think the facts of your case are, guess what? If you want to tell me stuff right now, anything that you say can be used against you at jury trial. That's where this ends up. So sometimes attorneys are trying to protect clients from themselves. I've had plenty of clients where I've had to protect them from themselves. And then some of them like, you know what? I'm still going to do my own thing. And I'm like, an explosion is going to occur and you're going to get the blowback from it. So you understand?
I do now. Yes, ma'am.
All right. See, sometimes we just need to,
I just need to talk. I'm sorry. This is my life and it's a very important day. I'm sorry.
no, here's the thing. Every single case is extremely important. People tell me sometimes I take too long on cases, but you know what I tell them? The person who's standing before me, this is extremely important to them because it's their life. This is a criminal court. You're looking at probation or you're looking at prison time. You understand?
Yes.
So that's where we are.
Yes, ma'am.
So is there any other issues with Mr. McCray? So then the next thing I need to discover from both parties is, where are we on discovery? This is where I'm trying to figure out if your attorney has received everything from the state that he needs to adequately and professionally represent you, okay? All right, so is there any outstanding discovery that you know of, Mr. McCray?
Not that I'm aware of.
All right, have you been, lately, there's been an issue with downloads. Have you been able to download everything?
Yes, sir.
All right. State, were you able to tender an offer?
I said her today, I only offer.
Okay, so here's the thing. The state has tendered an offer to you. I'm gonna have you sit in the box and internalize it because the state is saying that offer is for today. That's it. So I'm going to give you a chance to discuss that with your attorney. And if you decide you don't want to accept it, then we'll move towards a jury trial. Okay?
Okay.
All right. Thank you.
Thank you, ma'am.
You're welcome.